Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about Illinois custodianships. Custodianships are created by the Uniform Transfer to Minors Act. And basically what a custodianship is it's somebody transferring a piece of property to a minor in the custody of a different adult or trust company, or it could be their own custody. So it's a gift to a minor of a piece of property, but the minor, being a minor, can't control that property. So you name a custodian, a third party that is in custody and controls that property, and invests the property for the benefit of the minor until the minor reaches the age of majority or until the minor passes away. So a custodian is a little different from a guardianship. In a guardianship, you've got usually a deceased or incapacitated parent, and somebody else is named to be the guardian of the minor, and that person's in charge of all of that minor's legal and financial affairs. In a custodianship, you're taking one piece of property, and it can be multiple, but you do it at the property level, at the title of the property. You're taking one piece of property, and you're saying, I'm transferring this one piece of property to the minor, custody of this other adult, so that the custodian isn't in charge of all of the minor's affairs. It's just in charge of managing this one piece of property for the minor's benefit. The custodian has certain powers and responsibilities. The custodian has the power to distribute as much or as little of the property to the minor child as the custodian sees fit during the length of the custodianship. It can also make payments for anything that benefits the child from the custodial estate. The custodian can invest and reinvest the property and make transfers. So basically the custodian's got a pretty wide power to do whatever he or she sees fit with the property, as long as it's for the benefit of the child. The custodian also has some responsibilities. The most important is that the custodian has the responsibility to invest the property as a prudent person would with ordinary intelligence. So the custodian's not going to be liable for any losses to the property as long as they follow that prudent person standard. They don't engage in gross negligence or act in bad faith. Those are the three times that a custodian could be liable. And a custodian does have the right to be paid for their services as the custodian of the property. If they are paid, then the standard of liability is a little bit more intense on the custodian. So now let's talk about the process of creating and terminating custodianships. So there's not a lot of magic to creating a custodianship. You would create it by transferring property just like you would make any other transfer for that particular type of property. But you'd include magic language that's required by statute. So for most things other than real estate, you basically just have to say, in whatever document is transferring the property, I'm transferring the property to this person as custodian for this minor pursuant to the Uniform Transfers to Minors Act. With real estate, you've got to get the signature of the custodian on the deed and have them actually accept the property as well. So you should have an attorney do it because you've got to check some boxes with the statute, but it's not like drafting a trust. There's not a separate custodianship document. It's just when you transfer the property, there's going to be language in the document effectuating that transfer that says that you're doing it pursuant to the Uniform Transfers to Minors Act and following the instructions of the Act. And termination, it's pretty simple. The custodianship terminates when the child reaches the age of 18 or 21, depending on the type of custodianship. And at that point, the assets will go to the child. If the child passes away, the custodianship also terminates and the assets will go to the child's estate. Let's talk a little bit about tax issues. The custodianship is a gift to the child, and the child has ownership of that property even while it's in the custodianship. So typically the child is taxed on any income. So the child will pay income tax on income of the custodial estate. An exception is when the income for the custodial estate is used to satisfy a parent's child support obligation, in which case the parent would pay income tax on that. Estate tax operates a little bit differently. The items are usually included in the custodial items are usually included in the child's estate when the child passes away because they're the child's property. However, if the custodian is also the same person who was the donor of the custodial estate, so if I own real estate and I transfer it to my child, but I remain the custodian and I pass away while the custodianship is still in existence, then those items will be subject to estate tax in my estate. So it's the transferor who pays estate tax on it if the transferor is also the custodian and the estate terminates while the custodianship is still active. So thanks so much for listening. If you want to learn more about estate planning, real estate, or nearly any area of law, you can go to our website, learn-about-law.com, to see a lot more video, audio, and articles about nearly every area of law. You can call us at 630-324-6666 to schedule a free consultation. That's 630-324-6666, and we practice nearly every area of law. Go to seizeyourbusiness.com to check out our podcast and video blog about business, and go to makingrealestatefun.com to check out our new podcast and video blog about real estate. Thanks so much for listening.